Good morning, this is your Kelso Report for Thursday, March 29th. I'm your host, Clark Kelso. We have a good number of cases today involving sovereign immunity, immigration, sentencing law, criminal law, land use, licensed contractors, workers' comp, and arbitration. We begin with the United States Supreme Court that had 3 cases yesterday, the first dealing with issues involving sovereign immunity. The Privacy Act of 1974 contains a comprehensive and detailed set of requirements for the management of confidential records held by executive branch agencies. If an agency fails to comply with those requirements, quote, in such a way as to have an adverse effect on an individual, close quote, the Act authorizes the individual to bring a civil action against the agency. And for violations found to be intentional or willful, the United States is liable for, quote, actual damages, close quote. In FAA versus Cooper, the court held that actual damages under the Privacy Act does not include damages for mental or emotional distress. The court's holding here is a direct reflection of its general principle that waivers of sovereign immunity must be unmistakably clear, and that ambiguity regarding the scope of a waiver will generally be construed to preserve sovereign immunity. The history of the Privacy Act and its conceptual similarity to defamation law suggested to the majority that the phrase actual damages might mean only pecuniary damages, or in the language of defamation, special damages. In light of that ambiguity, the court applied its sovereign immunity canon of construction and held that the Act does not authorize recovery of damages for mental or emotional distress. It would not surprise me at all if Congress acted to overrule this decision, since emotional distress is one of the primary types of losses that occurs whenever someone's informational privacy is invaded and private information is improperly disclosed. And since the Act already limits the damages recovery to cases of intentional or willful violations, it's unlikely that expanding the scope of these damages would significantly burden the Treasury. Next, an immigration law case from the Supreme Court again. In 1996, Congress enacted the Illegal Immigration Reform and Immigrant Responsibility Act, IRERA, and one of its provisions effectively precluded foreign travel by lawful permanent residents who had been convicted of certain crimes. Under IRERA, such aliens, on return from a trip abroad, however brief, may be permanently removed from the United States. In Vartelis v. Holder, the court faced an alien who had been convicted prior to the enactment of IRERA on a plea, but who had traveled abroad after the enactment of IRERA and then returned to the United States. The issue for the court was whether to apply the pre-IRERA law to the case or the post-IRERA law. Congress did not speak to this retroactivity issue in the legislation, and the court held that the new provision precluding foreign travel attached a new disability, that is, denial of re-entry, in respect to a past event, that is, the alien's pre-IRERA offense, plea, and conviction. In light of the court's general reluctance to apply legislation retroactively, it held that the travel bar did not apply in the situation presented. Accordingly, the alien's brief travel abroad should have been analyzed under the pre-IRERA law, which generally permitted innocent, casual, and brief excursions outside the United States. The court remanded to the Second Circuit for it to apply the proper law to the case. Next, from the Supreme Court, we have a rather technical sentencing holding. In Setzer v. United States, the court held that the district court had authority to order that the federal sentence be consecutive to an anticipated state sentence that had not yet been imposed. The law here is actually pretty well established in favor of the court's holding. As the court noted, judges have long been understood to have discretion to select whether the sentences they impose will run concurrently or consecutively with respect to other sentences, either that they impose or that have been imposed in other proceedings, including state proceedings. So the only issue was whether that discretion extended to an anticipated state sentence, and quite a few of the circuit courts of appeal had already affirmed that such discretion existed. Finding no statutory bar, the Supreme Court agreed. As for the particular sentence in this case, a complication arose because the state court ordered its sentences to run concurrently, which created an apparent conflict with the federal sentence. Well, that conflict will be resolved in the first instance by the Federal Bureau of Prisons, which has the authority to determine how long the district court sentence authorizes it to confine the defendant. If the defendant disagrees with that calculation, it can administratively appeal and ultimately file a petition for a writ of habeas corpus. Now we turn to California Court of Appeal decisions. First, criminal law. Penal Code Section 26 exempts from criminal responsibility persons who committed the act charged without being conscious thereof. In People v. Wells, the 3rd District concluded that it was indisputably clear that the defendant, who was convicted of DUI and causing great bodily injury, was relying on involuntary unconsciousness as a defense. Based on discussions between the trial court and the parties, and on defense counsel's closing argument that the defendant could not be found guilty because the reason he crossed the double yellow lines was due to his low blood sugar causing him to pass out. In these circumstances, the court had a sua sponte duty to instruct the jury on the affirmative defense of unconsciousness. The 3rd District found the failure to instruct was prejudicial since there was a reasonable possibility the defendant would have obtained a more favorable outcome had the instruction been given. Next, we have a land use decision. In Jamieson v. City of Carpinteria, the 2nd District found that substantial evidence supported the city's determination that a condominium owner's proposed expansion of a patio would conflict with the city's rules and regulations regarding beachfront development. The property owner argued that a stipulated judgment entered into between a predecessor owner and the city in 1974 gave him a vested right to the proposed development. But that argument had been rejected by the Coastal Commission in a prior administrative proceeding from which the current owner had failed to seek judicial review. So he was now precluded from making that argument. Absent the vested rights argument, the city's action in denying his request for a permit was reviewed under the deferential substantial evidence doctrine, and the 2nd District affirmed the city's denial. Next, we turn to contract law and licensed contractors. Section 7031 of the Business and Professions Code generally bars an unlicensed contractor from being paid under a contract for work that requires the contractor to hold a valid license. In Montgomery Sansom LP v. Rezai, the trial court granted summary judgment to the defendant because it concluded that plaintiff, a general partnership, was not properly licensed. The plaintiff appealed, arguing that the general partnership was essentially the same legal entity as a limited partnership that was properly licensed. The 1st District agreed with the plaintiff. Under the applicable cases, the fact that the same business entity may operate under 2 slightly different names does not trigger the bar to recovery of Section 7031, so long as the business entity is properly licensed under one of its names. On the facts presented in the case, the Superior Court had incorrectly granted summary judgment, and the 1st District remanded for further proceedings. Next, workers' comp. A farm worker fell from a 24-foot-high ladder while picking avocados, and he suffered traumatic head injury leading to psychiatric injury. He filed a workers' comp claim. However, Labor Code Section 3208.3d bars claims of psychiatric injury if the applicant was employed less than 6 months, unless the injury is caused by a, quote, sudden and extraordinary employment condition, close quote. In Skiff v. Workers' Comp Board, the 2nd District held that while the fall was sudden, it was not extraordinary within the meaning of the statute because falling from a high ladder is an ordinary occupational hazard that was not uncommon, unusual, or unexpected given his job. The court affirmed the board's decision to deny the claim. Next, arbitration. An employee had signed a broad arbitration agreement in an employment application packet he received from the defendant. However, when he was subsequently hired, he signed another employment contract that contained an arbitration clause limited to arbitrating disputes arising out of a breach of contract. The clause did not contain the usual language extending arbitration to disputes arising out of or relating to this contract. And the contract contained a full integration clause, providing that the employment agreement was, quote, the entire agreement between the parties and supersedes all prior and contemporaneous discussions and understandings. So, in Gray versus American Management Services, the Second District held that the integration clause meant the written employment contract superseded the arbitration agreement contained in the employment application packet. And since the employee's discrimination claims were based on statutory violations instead of breaches of contract, the claim should not have been submitted to arbitration. On this basis, the Second District reversed the arbitration award that had been entered and remanded for further proceedings. And that's it for today's Kelso Report. Have a great day in the law.